Hello friends, in the series on the income tax cases, today we will discuss the issue of importance of service of notice under section 148. The question arises that if the revenue issues the notice to the assessee and if the notice is not served to the assessee and if the assessee during the assessment proceedings raises this point that the notice has not been served to the assessee as per section 282. So whether in the absence of the service of the notice to the assessee as per law, even if the assessee participates in the assessment proceedings, whether the assessment proceedings will be valid or not. This issue has been taken up by the Delhi High Court in the case of Principal Commissioner of Income Tax versus Atlanta Capital Private Limited, and this issue has been decided on 21st September 2015. This case although relates to the period of 2015, but it has been incorporated in 464 ITR, that is the latest ITR. The reason may be this case is very important for section 148 proceedings. There is section 282 which talks about the service of the notice, and there is section 292BB which talks about the notice to be valid in certain circumstances, meaning thereby that if the notice has some defects and if that defects are very general in nature, so the notice should not be quashed on that behalf. In the present case, the matter is related to the assessment year 2001-2. The notice was issued to the assessee under section 148. When this notice was issued to the assessee, this notice was issued at the address which was given in the income tax return of the assessment year 2001-2 for which the case was related. But in the return of the assessment year 2005-6, the assessee has changed his address, and when this address was changed, after this change in address, some communication was done by the revenue at the new address. And after some communications which has been done by the revenue at the new address, section 148 notice was sent to the old address after these communications at the new address. So, meaning thereby that the revenue was well aware of the new address of the assessee, and assessee raised this objection during the assessment proceeding itself that the notice has not been served to me according to section 282. But the assessment proceedings were completed. When this matter was before the tribunal, the assessee was challenging this assessment on the ground of non-service of the notice. The revenue gave the relief to the assessee. When the revenue moved to the High Court, by saying that this issue has been well taken up by the Delhi High Court in the case of Commissioner of Income Tax versus Chetan Gupta, which has been reported in 382 ITR at page number 613, dated 15 September 2015, in which Delhi High Court has laid down the rules for the service of the notice. That is, under section 148 subsection 1, the issue of notice and the service of the notice are jurisdictional requirements and not procedural requirements. The court also said that in that case that the service of the notice should be done according to section 282 subsection 1, read with order 5, rule 12 of Civil Procedure Code and order 3rd, rule 6 of Civil Procedure Code. The court also said that in that case that it is the burden is on the revenue to prove that the service of the notice has been done to the assessee. The court in that case also said that if the assessee participates in the assessment proceedings, even then the requirement of service of the notice according to section 282 should be met, and if the service of the notice is not done as per the procedure, then the whole assessment can be quashed. The court also said that section 292BB is prospective, and if the assessee has raised objection during the assessment proceedings about the service of the notice, then even the section 292BB will not come in the rescue of the department. The court said that the plea of the department that the assessee has not updated the details of the address and the other details in the PAN number. So for this, the court also said that there is no burden cast on the assessee as per the income tax rules or act to update the details in the PAN number. Friends, although in this case the Delhi High Court has quashed the notice by following and by confirming the order of the tribunal, but for one point I want to update you that in the present case, although it was said by Delhi High Court that it is not the duty of the assessee to update the PAN number, but in a recent judgment of 2019 of the Honorable Supreme Court in the case of CIT versus iVenture Interactive Limited, which has been reported in 418 ITR at page number 662, the Supreme Court has cast a duty on the assessee to update the details in the PAN number. This case holds equally good in the present circumstances when the notices are not sent by at the address by the registered speed post, but since the notices are sent through email, so the assessee can also take the plea of the service of the notice. But it is very essential that during the assessment proceedings we take this plea that the service of the notice has not been done as per the act. Friends, this case is very, very important. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Atlanta Capital Private Limited, and this case has been reported in 464 ITR at page number 341, and the date of the judgment is 21st September 2015. Thank you, friends.